Welcome to another video of U.S. Immigration TV. Today I want to talk with you about secret evidence denials, or when USCIS denies a case based on undisclosed records. Now, what typically happens with many people is that they file a petition or an application for immigration benefits, and then they get a request for evidence, a notice of intent to deny, or even a denial. And USCIS is saying, based on evidence we uncovered, we are denying your case. Or they say, based on a statement we've obtained from a witness or a confession from a former spouse, we're denying your case. But they do not provide the applicant with that evidence. They don't provide the records or the evidence, making it next to impossible for a person to meaningfully respond or refute the claims or allegations against them. Well, there is new hope, because recently the Ninth Circuit Court of Appeal, which is one level below the U.S. Supreme Court, stated that it is unconstitutional for USCIS to deny a case based on secret evidence or undisclosed records. They must provide the person with the records or evidence being used against them so they have an opportunity to respond. I mean, that is the essence of due process. Notice and an opportunity to be heard or defend yourself. Now, what happened in that case is that a U.S. citizen had petitioned his alien spouse, but the petition was denied. Why? Because USCIS said, based on evidence we've obtained, her marriage to a different U.S. citizen was fixed. Now, how things work is, if a person is ever caught in a fixed marriage, it's a lifetime ban. No future petition can be approved. So USCIS said, we caught her in a previous marriage that we consider to be fixed, therefore we are denying this U.S. citizen's petition. Well, they said, well, what's the records? What's the evidence? And USCIS would not tell them. They would not disclose the evidence. And it finally got into federal court, and it was only when it was in federal court that USCIS finally filed this evidence, which just happened to have been, in that case, a rental application that the first U.S. citizen had submitted listing his prior residences, but did not list the joint residence that he shared with her. So USCIS concluded it was fixed because they didn't live together. But the court said that because USCIS never provided that evidence, it denied these people their constitutional rights to due process. Now, this case is very important because I know that so many people have received requests for evidence or denials where USCIS is claiming that they have uncovered evidence showing that they are not eligible for the visa or their marriage is fixed, but they don't provide the evidence. Or sometimes they say, we've got a confession from your first spouse and he confessed the marriage was fixed. And they may only cite portions of the confession, but maybe other portions will be helpful to the alien. So that is why, if you or somebody you know has ever been denied based on evidence USCIS is relying on, but USCIS is not providing that evidence, you should see an attorney who can fight for you and require the USCIS to produce that evidence and help you respond or refute that evidence and show you are eligible for the benefit you're filing for. And I think that this may also apply to people who are seeking an immigrant visa at the U.S. embassies. Again, many times the embassy will say, we are denying you because of a misrepresentation. We are denying you because you do not have the proper relationship with the petitioner. And that's all they say. They don't say, well, what was the fraud? Or how come I don't have the proper relationship? This case is important because it would require the government to provide people with the evidence, with the records, with the statements that is being used against them. That's the essence of the Due Process Clause of the U.S. Constitution. And so, therefore, I say it is very important, even if this happened a long time ago, there could still be hope to go back to the government and ask them to reopen or reconsider and to fight for the benefit that you may be legitimately entitled to. Now, please, don't forget that if you like these videos, if you find them informative, if you find them helpful to yourself or to your family or to people you know, make sure that you like, share, and most importantly, subscribe. We will continue to keep you updated on any developments in immigration law which may be of use to you. I'm Michael Gurfinkel, and this is U.S. Immigration TV.